Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
I'm Elizabeth Morris. I'm an IP attorney and director of intellectual property and products at Pure Storage in Mountain View, California, and I am one of your hosts.
As we learned in a previous episode, there have been more than 20,000 unitary patents requested. The patent space in Europe is changing, and from recent statistics, the United States is the largest non-European filer at the European Patent Office, with around a quarter of its total applications in 2024. That year, semiconductor giant Samsung was the top applicant, and filings in the electrical, semiconductor, and computer technology space are all up. Electrical and semiconductor patent application filings were up 8% in 2024 compared to previous year, and computer technology was similar, with application filings up more than 3% in 2024 compared to the previous year. However, as U.S. patent practitioners know, the European patent system can be at times very different from the U.S., and what happened during examination of the U.S. patent application may not give you a viable path for the corresponding patent application in Europe. So in this episode, we want to explore the intricacies or quirks of two parts of European patent law: obviousness and everyone's favorite, intermediate generalization. And we're joined on this episode by Phil Sanger from Grey Wolf IP in the United Kingdom to learn more. Phil, welcome to the podcast. Could you please start us off with a quick introduction to yourself?
Of course. Thank you for having me. So my name's Phil Sanger. I'm a UK chartered and European patent attorney. I've got my own firm, which I've been going for about 5 years now. I started life as an engineer, so that's kind of very much my background. I'm a mechanical engineer and then converted to do patent law. So a lot of my clients are in that space, but increasingly over the years, I've kind of diversified and, been having a bit of a thirst for knowledge, work in various different sectors now, including software and also semiconductors.
Phil, it's so great to meet you. Thanks for being on. I didn't realize you were a mechanical engineer, sort of turned a little bit more electrical focused, right? Semiconductor focused. That's actually my background as well. I'm also a mechanical engineer, and living out here in Silicon Valley, have definitely gotten pulled in the semiconductor direction. So really happy to have you on. Nathaniel and I have done a couple of episodes now on European patent law, but it's still somewhat baffling. So we're really happy to have you here. To start out, so we're familiar with obviousness in the U.S. and American attorneys' way, but what is the standard for obviousness when you're prosecuting a patent application in Europe?
Yeah, so it's a very structured approach we have in Europe. I mean, as I understand, in the US, there is some degree of flexibility that the examiner has with the kind of the Graham factors and the KSR approach. By contrast, in Europe, the examiners are kind of constrained to what we call the problem solution approach. And it's a very rigid framework that examiners need to stick to. And the idea behind it is really to kind of reduce the level of hindsight that an examiner can use when they're looking at an invention. And, very briefly, to kind of talk you through that approach, essentially there's 3 steps to it. The first step is you have to choose what we call the closest prior art. So unlike in the US and indeed in the UK to some extent, where you can really start from any document you like to build an inventive step attack, in Europe, you have to choose the one that's closest. And closest really means, is it in the same technical field? Does it have a lot of the features in common? Is it directed to broadly the same problem? And there are various criteria used to assess which document that is. And that's a factual exercise. There is only one closest prior art document. Once you've got that, the second step is to define what we call the objective technical problem. And that involves looking at the differences between your invention and the closest prior art. So you've got a couple of novel features there compared to that closest prior art document. You look at those novel features and you say, what's the technical effect? What's the benefit that these features are providing? And that then allows you to construct your objective technical problem. So, for example, if the novel, let's take a very kind of trite example. Let's say your novel feature is a material that's less resistive. You might argue, well, my objective technical problem is, a lower resistance, and therefore it's more efficient. So you then go on to step 3, having created that objective technical problem, which is to kind of forget about the invention completely, put it out of your mind, Then you go back to your closest prior art document, you take your objective technical problem, and you say, given this closest prior art document and given this problem that I've now created, is it obvious to move to the invention? So the idea behind that is you have no hindsight of the invention. All you've got is the prior art and a problem which has been created from those novel features. And the question is, at the end of the day, is that an obvious thing to do for your notional skilled person?
So where do you see this standard or this technique, procedure, whatever you want to call it, where does it usually cause problems for someone who's accustomed to analyzing a rejection in a patent application using the US obviousness standard? Where does a US patent practitioner trip up? Because I know sometimes when I see proposed arguments in Europe, I think we're arguing about vibes, right? It's this doesn't seem like anything that I would be able to do in the US.
Yeah, got to get the vibes right. So I think one of the issues we see is that the US, when I'm instructed by US attorneys, often I find the arguments are kind of broad but shallow, if you like. So there's lots of arguments about, well, if you start from document 1, then it's not obvious because if you start from document 2, and so on and so forth. So I think you've got to really focus on this idea of this rigidity of the problem solution approach. And so addressing the closest prior art is really important. And once we've nailed that, then you kind of follow the process through. There's no need to kind of waste time and effort going to lots and lots of different starting points. The other thing is, I think, to kind of focus on the technical effects, because a really important part of this process is defining that objective technical problem. So it's really useful to be able to point to the specification and say, quite clearly, this novel feature has this effect, and construct the problem that way. It is possible to kind of argue those technical effects outside the disclosure of the application, but it needs to be something the skilled person would understand. And we've also got to we can be quite detailed and specific. So I certainly know the US attorneys who I instruct can often be a little frustrated when I say, well, clearly you wouldn't combine these two documents. They're completely incompatible. But as I understand that approach does not work with US examiners, because it's all about motivation to combine. Whereas, we're really looking at the details. So if there is a good technical reason why document A and document B simply would not work together, if they're fundamentally incompatible for a technical reason, that is a solid argument against why that particular combination wouldn't work. So you really got to dig into the technical detail, which is again why those kind of high level benefits. So this just improves performance. They don't really work. You've really got to nail what exact technical effect am I seeing as a result of this novel combination of features.
That's really fascinating. I don't think I have ever in the US won an argument on motivation to combine. So how much can you rely on flaws in motivation to combine at the EPO? Like, does that really work?
Yeah, absolutely. As I say, you can really dive into the detail about this particular combination of features. I think the first thing, as I said, is to look at the closest prior art document. That's always going to be your starting point. So just work out whether that is an appropriate place to begin, because often you can undermine the whole the whole obviousness argument looking at that. So examiners often get a little overexcited about a piece of prior art that may share many of the features of the invention, but maybe from a completely different technical field. And under those circumstances, well, you can argue, the skilled person would not look at this without a significant degree of hindsight. They've always got to start from the technical field they know, or at least technical fields that are very closely related. So that's I think the first point. And once you can argue that they've got the closest prior art wrong, the whole kind of problem solution chain, if you like, collapses. But yeah, as I say, documents have to be practically compatible to combine. So the skilled person's got to see a way in which these two things can work together. And if they don't, then obviously, he or she would not necessarily combine them. And I think it's also useful to bear in mind what technical problems the prior art documents purport to solve, because ultimately the analysis you're doing, as I mentioned before, is you're starting from the closest prior art and you're addressing a problem, a very specific problem. If the prior art, the second prior art document, doesn't teach solving that problem by introducing the missing features, then it's not necessarily an obvious place to go. If those features are there for a completely different reason, solving an entirely different problem, then there's not necessarily that logical flow from problem to solution, which, the clue's in the name. That's what the problem solution approach is really all about. And I guess the other thing to bear in mind is that, the modification has to be straightforward. It's not, unlike the US, in Europe, if you're combining two documents, there's almost a presumption that there is some essence of inventive step there. You very rarely, if ever, see under very limited circumstances, would a European examiner combine more than two documents. So as soon as you've got two documents there needs to be a very low bar to the skilled person combining them, and a very strong teaching in the direction of doing so.
Now that you've dispelled some of the confusion on the obviousness piece, let's assume for a minute that we had to amend the claims to get around a rejection. Could you, for our American listeners, explain what intermediate generalization is? Because it's not something that exists over here.
Absolutely. Well, I'll do my best. Sometimes I feel like it's explaining the offside rule. So intermediate generalization, well, as you know, in Europe, the law is very hung up on this idea of added matter. Like, you must never add anything to a patent application after it's been filed. And intermediate generalization is essentially kind of an extension of that idea, or a kind of form of that idea. So in a nutshell, intermediate generalization is extracting a single feature from an embodiment or other combination of features without bringing those other features with it. So to use an example, let's talk about semiconductors. So if we've got a MOSFET, let's say a trench MOSFET, it's got a rounded trench bottom, it's got dual doped sidewalls, it's been annealed at 900 Celsius, something like that. Okay, that's your embodiment. And you say to yourself, well, okay, I've got a problem with claim 1. I could really do with adding this kind of rounded trench bottom into my claim 1. If you take that one feature in isolation, without taking the dual doped sidewalls and the 900-degree annealing, then you may well face an objection on the basis of intermediate generalization, because what you're doing is, although the application as filed discloses that feature, it only discloses it in combination with a set of other features. So what the European Patent Office are essentially saying is that you have generalized that embodiment, and that generalization was not disclosed in the application as filed, and therefore it is added matter. So I hope that makes sense.
So are you saying in this particular example that if you amended the claims, you couldn't just add the rounded trench bottom, you'd have to add the other aspects as well to get there? Is that what the examiner would argue?
Yes, absolutely. That's what they'll be arguing, and I've seen it many times before, and some quite outrageous proposals from the examiner about, can you just add these features to your claim, and you'll see, a half a page paragraph with many additional features, basically reproducing the description of the embodiment. Do you mind just putting this into your claim? And obviously, if you were to do so, your client would probably be less than happy with that solution.
Yeah, that's fascinating. So is there a way to fight this kind of rejection? I mean, obviously you would not want to add the half a page description into the claims, or are you just kind of stuck?
No, you're never stuck, or very rarely stuck, I would say. So essentially, you need to be in a position to argue that the skilled person would understand that feature could be isolated from that embodiment and transferred into the claims. So there are various ways of doing that. One approach would be that you could argue that the other features that the examiner is suggesting that you bring are not essential, and the skilled person would understand that they are not essential, either because they are explicitly stated as such. So, for example, the embodiment may say this particular structure may be annealed at temperature X. Well, that to me suggests it's optional, not essential. So that's one way to do it, is looking for those kind of clues about whether these features are necessary. You can also argue an implicit disclosure based on the skilled person's common general knowledge. So if your skilled addressee was reading this, would they understand that these features are separable? And that really comes down to whether they're synergistic or not. And that's kind of an argument that I use quite a lot, is that clearly the feature of the, going back to our example, the shape of the bottom of the trench is not linked to how this thing was manufactured. in the first place. Those are two entirely separate features, and the skilled person will understand that they are completely separable because they have no synergistic effect whatsoever. And that argument, can also be quite successful. I think, obviously, sometimes you can add some features in that are not overly limiting. So I think there is some benefits to possibly looking at all of the features the examiner is suggesting. And there may be some features where you can say this is clearly optional, or this is not synergistic. But there may be some where you're having more difficulty. And I'd just consider adding those into the claim. It's not always a bad thing. So sometimes you have examples where actually realistically every potential infringement of this patent claim is going to have this feature. Do we really need to, push back this hard on it? So sometimes there's kind of an intermediate point, if you like, between what the examiner is saying and what you're proposing. And obviously, I suppose the other thing you can think about is, do those, when you're talking about synergistic effect, is do the features the examiner is proposing solve a different technical problem to the ones that you are, you're wanting to import? If the effects of those two features are very different, they do different things, there's an argument there that they don't necessarily belong hand in hand and need to be carried through together.
So you have options to fight, or at least maybe negotiate a smaller subset of the original proposal from the examiner. But assuming you're trying to avoid this, is there a way to draft a specification for the US case or the PCT that gives you the arguments you need later? So I'm thinking, in your example with the device design with an annealing temperature of 900, I assume you'd be in a different position if it said the annealing temperature may be between 900 and 950, but other values are possible, versus having an example where it says, in example 1, the annealing temperature was 900, and look at this beautiful device structure that resulted. Those probably would give you different sets of arguments, right?
Yeah, absolutely. I think the inclusion of ranges, of fallback positions is a really good idea for this, because it just builds in those intermediate positions, which is what we're after. At the end of the day, we are trying to make an intermediate step between what was originally claimed and, the embodiment. So having all those fallback positions in there is a really good idea. Whether they're in, you'll find a lot of European attorneys tend to put those in the statements of invention. But I've seen a lot of US specs where they tend to go in the specific description. But it doesn't really matter, just as long as you've got that, those fallback positions and that language in there. That's really, really, really beneficial for this kind of thing. I think you're right. A lot of this is all happens at the drafting stage, and that's the key to avoiding intermediate, generalization. I'm aware to some extent you're kind of, perhaps me advising this is slamming the stable door after the horse has bolted, but drafting is so important in terms of avoiding this kind of rejection. And what we really need is kind of almost a modular disclosure, where we've got all these different features, and they all slot together in one particular way in our preferred embodiment, but they can also be separated and used independently and in different combinations. So, as I say, there are different ways of expressing that, but that's a really useful thing to be able to do, which is, as I say, why we get quite hung up on making sure our statements of invention are nice and broad. And we have also the benefit of you being able to use multiple dependencies in our claim sets in Europe, which really helps pick out. It just gives you much more flexibility in terms of claim combinations. I'd say the other thing you can do is look at explicit optionality. So, when you're saying may be used, optionally be used, this is independent of that. So being quite explicit about those features that you think are separable. And also talking about the technical effects of each feature can be really useful as well. I mean, I don't know how well that fits with US practice. I've certainly had some US attorneys, raise an eyebrow at kind of going too much into, this is the benefit of this feature and this is the technical effect of that feature. But the more technical effects you have for each feature, and that then gives you the ability to differentiate them and say, this thing does something different to this thing, therefore I can import it without dragging the rest of the embodiment in. And I guess the other thing is multiple embodiments. So if you've got lots of different embodiments which all have different combinations, that will allow you then to kind of extract a common feature from those embodiments, which clearly can be used in isolation because it appears in different variations of the invention. And I guess, it's just avoiding that kind of monolithic single story type patent draft, which may make for a really engaging read, but ultimately it can cause you problems if you just focus too heavily on this is the problem, this is the one solution we've developed, full stop. It needs to be a lot more, or you could do this or you could do that, and here are some variations on this. All of that really, really helps us when we get further down the line in European examination.
I like how you commented on the readability of patents, because they're almost unreadable, even in their current engaging format, perhaps. But digging a little bit more into specification drafting, this is something that I've been thinking about more recently, especially as, we all are thinking, clearly, as Nathaniel said at the beginning, right? Unitary patents requested is up, and is up in our fields. So we're seeing our competitors using this space, and we maybe need to be drafting more in a more European style. I have had European attorneys recommend that I send drafts over to them prior to filing if I have a pretty good idea that some of these things I would want to file in Europe. But I've never although I think it's a great idea, I've never managed to actually do it because, it slows down the process. I do have a couple, I think, of AI vendors now that are saying that they could provide a tool that would sort of, recommend things that could be more helpful. We could sort of load our specification into it and it would spit out some ideas. I'm a little dubious about whether that would work in an AI context, or if it needs to really be attorney reviewed kind of. What do you think about that? Do you think AI could handle making recommendations that could be helpful in producing a specification that's more Europe friendly, that's probably written by a US attorney?
I think it is possible. Yeah, I mean, if you kind of think about the broad way that I've described, though, those kind of tips that I gave about modular disclosure and optionality and those kind of things, it'd be reasonably straightforward for an LLM to kind of rewrite your spec, or certainly add those elements into it, because they're kind of quite, it's a grammatical exercise, really, isn't it? I think the value the attorney brings, and this is probably you as the client working with the European attorney, is to identify actually which features or combinations of features are going to be important. That's something in AI wouldn't necessarily understand, is the commercial slant on all this. So which combinations or which single features are going to be really important to what the client's trying to achieve commercially, and then really focusing in on those and making sure that you're following this kind of idea of modularization around those specific features, I think would be really useful. I guess the other thing, thinking about it, is I listened to your recent podcast on unitary patents, and I think one of the suggestions was that you might like to use the combination of the unitary patent on the one hand, and then a division or two, a traditional European patent, to give you kind of the best of both worlds. And the problem you have is a rejection on double patenting. So you need to have two slightly different but overlapping claims in order to do that. And I think, engaging, because of it's going to be very difficult to create that slightly different but overlapping claim without having kind of baked it into the application up front. So, I think certainly discussing that with a European attorney as well will give you the ability to make sure that you've got, in particular, the statements of invention that allow you to do that into the application from the start.
Well, Phil, thank you for your insights on what can be a foreign set of rules to us here in the US. Appreciate the clarity that you brought on something, the intermediate generalization, which is something that I faced once and was left perplexed as to, you want me to do what? and bringing some good pointers in terms of how we can build our specs better, or get make an early phone call to try to bake in some fallback positions before this becomes a crisis. So thank you so much for joining us on today's episode. Hope to have you back again and hear more about some of the insights into what's going on in Europe as we continue to file as the semiconductor industry over on the other side of the Atlantic.
Thank you very much. It's been my pleasure.
Yeah, this was a great episode. Thank you so much, Phil. I hope we can maybe catch up with you again in a year. We've done that when things change over time. So yeah, thanks so much.
Thank you.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.